All right. Is this on? Can you hear me? Can you hear me? Okay. Welcome everyone to the New Lawyer Training Program Ethics Course. Thank you all for coming out, even in this weather that decided to finally become fall. It just chose the perfect day when we all needed to come here. But I'm grateful that you all made it in and made it in safely. Hopefully safely, and make it back safely as well. But thank you for being here. And thank you for being on top of your requirements for the New Lawyer Training Program. This is one of the key components and necessary requirements to fulfill your program. So I'm really happy you're here, and we don't have to track you down. I would say that this time of year that we are doing that for some of your counterparts who haven't been doing what they're supposed to be doing. So thank you for keeping on top of everything, and that's, like I said, nice to see this. And this program is designed as part of the New Lawyer Training Program to give you some of this ethics and professionalism workshopping and presentations, and kind of just to model what you will be doing as you go on past this program year after year in your CLE requirements, which will be that you will need to get one ethics and one professionalism credit each year. So this, like I said, we're trying to help model that, and this is also a good program. You'll be hearing from many different people here today. Let me just go forward to the agenda. Just also it is to teach some professionalism and ethics, but also to introduce you to some of the people that it'd be good to know, and a few that is good to know, but hopefully you don't ever have to interact with very much. And then I mentioned that is the Office of Professional Conduct is one that is really vital to know what they do, but hopefully you don't ever have to interact with them too closely, but it is good to know what services they offer and who they are. And again, like I said, we will be working through this. There will be a break at 10:15 for 10 minutes. And at any point in time, feel free to get up there. If you haven't seen already, there's drinks and snacks in the back. Feel free to get up at any time and go grab those. And there are restrooms out here in the lobby. Men's are on this side, women's are on the other side. And there's also on the same setup upstairs if you need to. So, and the stairs are right here, or the elevators right there. So thank you again for being here. And at this time, I'm going to turn some time over to Judge Jeremiah Humes of the 7th Judicial District.
Thanks, Sean. Appreciate the invitation to be here with you. Hopefully I'm not messing anything up there. As John said, I'm Judge Humes from the 7th District. Really, all you need to know about that is it's not the Wasatch Front. I remember when I was a lawyer for about 10 minutes, I was working at a general practice law firm. We had 3 lawyers, including myself, so 2 partners and me. And I was assigned to do my first contested hearing. It was a temporary orders hearing on a child custody matter of a little girl that was about 3 years old. And my client had been the victim of physical abuse, and she was really nervous about the hearing. And so as we sat there, we waited through the law in motion calendar as all the other matters were taken, and to the end when the judge was going to take the contested matters. And as I sat there thinking through what I was going to do, I was a little nervous, and it came time for our case to be called, and I started to gather my things from my notes and things from the bench. My client was sitting next to me, and she leaned over and whispered in my ear, "Please do your very best. I'm trusting you with my baby." And at that point, I was completely terrified. Things worked out well, but needless to say, I became very acutely aware of the gravity of the work that I was doing in a way that had never really settled on me before. I wonder if any of you have sort of felt maybe the gravity of the work that you're doing, or felt a time when you realized that you've been allowed to do some work that's pretty important. If you'll indulge me, I'd like you to take, I want this to be a little bit interactive, so I'd like you to take just a moment, turn to somebody next to you and share something that came to mind. If anything came to mind, I just want to take a couple minutes to do that. So go ahead and share something that came to mind. All right. Thank you for indulging me there. Thank you for indulging me for a moment. If I can have your attention back. So this is very interesting to me. Clearly, a lot of you are very comfortable with one another. I wondered if it would be difficult to get you to talk to one another, but clearly not. That's not the case. So thank you for that. I want to share a second story with you. Again, this was around the same time I was a very new lawyer, and again, a general practice firm. We're doing all kinds of things. I received a phone call. We received a phone call at the office, and the assistant passed the call to me, and it was a lawyer from a Salt Lake City law firm. And he was asking if we were available to do, they had foreclosed a property in Moab, and they wanted to know if we were available to do a trustee sale. And as I listened, I thought to myself, are those the things that you do on the courthouse steps? And in my most professional lawyer voice, I said, yes, let me check my calendar. And can you hold? And I put the phone down and I ran across to my boss who had just walked in the office. And I told him what the call was and asked him if we could do a trustee sale. And he said, you bet. So I walked back and picked up the phone and told the lawyer, you bet, we can do it. And he said, great, I'll get the details of the sale to you on the day of the sale. And I thanked him and hung up the phone, walked straight back across the hall and said, how do you do a trustee sale? And my boss said, I don't know, I've never done one. And he said, I'm sure the code will tell you. Well, the code does not tell you. So I spent a lot of time looking at the real estate code and seeing if I could figure that out. And I put some things together and got a few ideas from my boss. And I thought, well, I can probably muddle through this. And I ran everything by the partner before I left. And he said, yeah, that looks great. And the day of the sale came around and I still wasn't feeling confident at all about my ability to conduct this sale. And so I called the lawyer in Salt Lake to get the details of the sale. And mind you, at this point, based on nothing, I had envisioned that I was going to be selling this dilapidated home down by the river that had been in foreclosure for years out in rural Utah. As we spoke, he informed me that I would be selling a hotel for several $1 million. There would be a lot of local interest and a possible bankruptcy in the process. And At this point, I thought it was probably prudent to let him know that I had never done this before. Like a true pro, he didn't miss a beat. And he said, no problem, I'll walk you through the whole thing. And he did. And he prepared me for all the things I needed to know, told me exactly what I needed to say, which is not in the code at all, and how to be prepared for the things that I might deal with. So after I finished talking to him and getting things in order, I was there early to be able to do that. And I had parked somewhere else as I made those calls. And I got to the courthouse. And as I started walking up to the courthouse steps, sure enough, there was a crowd of about 50 to 100 people there. And then I got there with my newfound confidence, now knowing what I was doing, and started to conduct the sale and take some bids on the property. And just like the scene out of a movie, a guy comes screeching in about a block away, because that's the closest parking spot, running across the courthouse lawn, waving papers, saying, we've filed. And sure enough, they'd filed bankruptcy. And so I followed the procedure that we had discussed, and we ended up postponing the sale. In case you're curious, I did end up selling the hotel later. I tell you these stories because, in my view, these are exactly the sorts of things that the new lawyer training program is about. It's a judgment-free zone. Nobody, as a new lawyer, wants to look dumb. They don't want to look unprepared. They don't want their client to know how scared they are that they're going to lose the hearing. This new lawyer training program is a judgment-free zone where you can meet with someone who is experienced, who has been selected by a committee to represent the best that Utah lawyers have to offer and to guide you as you transition into your life as a new lawyer. It allows you time to explore areas of the law that you may not be interested in, you may not know that you're interested in, and do that in a controlled environment with some input from someone who knows more about those things. It also allows you to network with your mentor and all of your mentors' contacts, friendships, and be able to develop those things which will serve you well throughout your career. If you had asked me when I was sitting in your seat if I would have been a prosecutor for many years and been a judge, I would have said no way. I would have never thought that this is where I would end up in my career. So I would just say to you, never say never. Explore those things while you have the opportunity to do that. Approach it in explore mode. Just check everything out. Enjoy the time that you have. I know you're under a lot of pressures with the things that you have going on in your life, but it's a great opportunity that won't present itself later. Hopefully you'll be able to have some mentors in your life beyond the new lawyer training program. But this is an opportunity to engage with someone in a structured way. The new lawyer training program provides a framework for you to do that, to specifically set aside some time to explore these areas of law, talk about some of the rules that you may not talk about outside of the context, and look into some things that you may not be familiar or comfortable with. For any of you law nerds that are out there, the new lawyer training program is required by the Utah Supreme Court under Utah Code of Judicial Administration 14808, under the Supreme Court's constitutional authority to govern the practice of law, which is granted by Article 8, Section 4 of the Utah State Constitution, and which has been granted by the people of Utah. The program is administered by the Utah State Bar, as authorized and directed by Supreme Court Rule of Judicial Administration 14102. The only reason I mention that, which I think is very important, is to understand that the reason that you're doing the program is to serve the people of Utah better. And to have an opportunity to learn how to be the best lawyer you can be. And the Utah Supreme Court has felt that this is one of the best ways for you to do that, to engage with someone who has conducted a trustee sale before, has conducted temporary order sharings before, and can give you some insights on how to do that like a pro. Um, if you would, raise your hand if you've taken the oath in the last year. Almost everybody? Okay. So I was able to do that for a young lawyer just this last week. And I just want to remind you what the oath was in case you were nervous that day or excited or whatever. I do solemnly swear that I will support, obey, and defend the Constitution of the United States and the Constitution of the State of Utah. I will discharge the duties of attorney and counselor at law as an officer of the courts with honesty, fidelity, professionalism, and civility. And I will faithfully observe the rules of professional conduct and the standards of professionalism and civility promulgated by the Supreme Court of the State of Utah. Because of your training, you are now uniquely qualified and permitted to assist society with its most difficult circumstances. But that doesn't make you special or better than anyone else. When I knew that I was going to be giving this presentation to new lawyers, I went to who I always go to for wise advice, and that is my judicial assistants. And I said, what would you have the new lawyers know? And nearly without exception, they said, be nice. And which I wasn't too surprised that they were going to say. And then one of them said, yesterday was the first time I've had a lawyer be nice to me on the phone, which was astounding to me because she's worked at the court for a year. In the last 2 days, I've handled about 160 cases on my calendars. And all of those have had some sort of attorney-client or attorney interactions with the court, at least on some level. If a year is the first time that a judicial assistant had a lawyer be nice to them, we can do better. Just from a very practical standpoint, let me tell you why that's important. First of all, the judicial assistants are professionals just like you. You may be astounded at the amount of work they have to do and the amount of knowledge they need. Just like you, they have to be familiar with all the rule changes, all the statute changes, all the procedural things that are happening with the court. This is a time in the practice of law that is changing faster than it ever has changed. I think in the last 5 years, the practice of law has changed more than any time in my career combined. And it continues to change at that same rate. And they need to be up to speed on those just like you do. In addition to that, when people come through the door of the courthouse, meaning the patrons of the court, it's likely the worst day in their life. They're facing the most challenging circumstances they've ever faced. Their world may be falling apart, and they may be very angry about what's happened to them or the situation they found themselves in. And guess who gets to receive the brunt of that? The judicial assistant. They don't need the professional, meaning you and me, to treat them in a way that is unprofessional. In addition to that, they can make your life very easy because they know what the judge wants. They know the local practice. They know the judge's preferences. They know the document processes. And you can ask them about those things. Do not ask them how to practice law. They are reminded over and over, do not give legal advice. And so if you need to figure out the law, you're trained to do that. And you all are very good at doing that. So do that on your own. But if you want to know how the document ought to be presented, the way the judge likes his exhibits or her exhibits handled, ask them those things because they can provide you very good information on those things and they can make your life very easy. My predecessor, who I practiced in front of for many years, used to say there's no return on rude behavior. And I completely agree. One positive experience that I had in that regard is, as a prosecutor, I tried to recognize that, well, as it was brought to my attention yesterday in a sentencing hearing, nobody is either all good or all bad. And that includes the criminal defendants that I was prosecuting their cases or that come before the court. Everybody has good things that they have about them and that are going for them. And some people have made mistakes. And so I try to always to treat people with respect, no matter their circumstances. One day I was handling a justice court calendar in a tiny town in eastern Utah. And I finished the calendar and some of the maintenance guys came in and said, "Hey, we're grilling burgers out in the shop. You want to come out?" And I was like, "You bet. I've never passed up a burger." So I went out to the shop and joined them for burgers. And I knew everyone there but one guy. And so I looked at him and he had his name on his shirt there. And so I said, "Hey, Tracy, I'm Jeremy." And he's like, "I know who you are." And I said, "Oh, how do you know me?" And he said, "You sent me to prison." And so everyone just kind of went quiet and I was like, "Well, awkward." And he started laughing and everyone else started laughing. And he said, "No, it was the best thing that ever happened to me." He said, "It was what I needed and I appreciate the way you treated me through that process." And so it just highlighted to me how important that is. Because if I had treated him differently, that situation would have been a much different situation. And I was grateful that it turned out the way that it did. So my first point there is be nice, be fair, treat everybody with respect, no matter who they are, from judicial assistants to clients to opposing counsel. And I just want to touch I'm sure you're aware, I'm pulling all of this from 14301, the Standards of Professionalism and Civility. But let me just read the preamble for you if I could. A lawyer's conduct should be characterized at all times by personal courtesy and professional integrity in the fullest sense of those terms. In fulfilling the duty to represent clients vigorously as lawyers, we must be mindful of our obligations to the administration of justice, which is a truth-seeking process designed to resolve human and societal problems in a rational, peaceful, and efficient manner. We must remain committed to the rule of law as the foundation for a just and peaceful society. Lawyers should exhibit courtesy, candor, and cooperation in dealing with the public and participating in the legal system. My next point is be competent, be prepared, and be on time. As I was talking to a longtime friend and mentor recently, he was giving advice to a young lawyer, and he said, "There's two things that I would tell you." He said, "When you enter the courtroom, you should know you're the smartest person in the room. And the reason you should know that is because you know the facts better than anyone else. You know the law better than anyone else. And you have prepared to present all of that to the decider of fact or law." And he said, the second thing is you should be humble and wise enough to know to not let anyone else know that you think that. And I thought that was sage advice. When you come to court, as a judge, it's interesting to see all of the different approaches and strategies out there that exist. But my favorite, and I would argue is by far the most effective, is the calm, confident professional. They're never rude to the other side. They're not overly aggressive. I would argue they're not even aggressive. They just simply argue effectively. It's really difficult to argue with reasonableness. And it's very, very persuasive. If you're prepared, you recognize your arguments that are not great and don't spend time on those. They distract and dilute the effectiveness of your really good arguments. And when you've prepared, you can recognize those things. When you're unprepared, that's when you get to throw everything up to see what sticks, which in my view is not effective. Another story, if I could briefly, there was one time I was in the middle of a double homicide trial, and needless to say, that was pretty stressful for me, and I was having trouble with my exhibits and I couldn't get them to play. And the judge was getting short-tempered, and I lashed out at the judge in an unprofessional way, and basically said, "I'll present my case the way I want to, Judge." And to this day, I thank my lucky stars I was not held in contempt. Previous to that, I had been at a continuing education where Judge Roth had spoken to us from the Court of Appeals, and he was sharing some advice. And he said most bad behavior between lawyers or in the courtroom is driven by fear. Fear of incompetence, fear of embarrassment, fear of a bad outcome, fear of losing, fear of looking stupid. And I completely agree. The reason that I acted poorly in that situation is because I was fearful of looking stupid in front of the jury, looking stupid in front of the court. And that was what drove my bad behavior. And I only made it worse. And so I think it's important, if you can recognize that, if you start to feel the pressure coming on, identify, why is it that I'm feeling that way? Am I unprepared? Do I not know the law? Do I not know the facts? Am I worried there's going to be a bad outcome here? Maybe I'm taking an unreasonable position, and that's why there's likely a bad outcome. So I think if you can recognize that, as soon as you start to feel that pressure, recognize it and look at it and say, why am I feeling that? And I think it will help you evaluate the strength or weakness of your case and any areas of deficiency that you may have. Secondly, on that point, tech is huge these days. I just want to be quick on that. Know your tech. You got to know how to present your exhibits. You got to know how to handle all of the technology that exists, how to work with that, or find people who do know so that you can be effective in presenting your case, doing your discovery, and being able to be ready for that. Along those lines, let me just mention the next tip I would have for you is look the part and act the part. If I can, let me refer you to the comment to professionalism rule subsection 1. Lawyers should maintain dignity and decorum of judicial and administrative proceedings, as well as the esteem of the legal profession. Respect for the court includes lawyers' dress and conduct. When appearing in court, lawyers should dress professionally and use appropriate language, maintain a professional demeanor. I think this is a bit of a side effect following COVID and the many WebEx hearings. And let me just touch on that for a second. WebEx hearings can be good and bad. It can be a pain. But if you live where I live, it is absolutely an access to justice essential. From one of my courthouses to another of my courthouses is 3 hours and 15 minutes one way. And there are about 20 lawyers in 1/4 of the state where I live total. So if you live in Monticello, Utah, and you're getting a divorce, it's likely your attorney is coming from Provo or Salt Lake, which is a 5.5-hour drive. And if you're paying the lawyer to drive all of that way to conduct a hearing, you can't afford to do it. And so those kind of hearings are essential. So we conduct a lot of them. 99% of what I do is on WebEx. If you're appearing by WebEx, wear a shirt. Don't appear in your car. Put your cat in the other room. You would not believe the things that I've seen. Many of them from lawyers. I have told lawyers to pull over many, many times. You're breaking the law on the record, counsel. Please pull over. Anyway, be professional, look professional. I tell people continually, stop smoking. This is a courtroom. I don't allow smoking in my courtroom. Please put it out. Even though we're virtual and you might be appearing in your home, I think we need to maintain the dignity of the proceedings and give it the respect it deserves. So please, lawyers, appear appropriate, be ready, have an appropriate background or room or something like that that you can conduct your hearing in. If you're joining online, comb your hair, whatever you need to do. But just make sure you look professional as you engage in the process. And always, as I've mentioned, treat opposing counsel with respect, follow the rules. I would also suggest for you that are building a practice, every time you appear in court, you have 30 to 150 people that are watching you that are all potential clients or referral sources. So if you show up in your t-shirt, that may not be the person that they're going to refer someone to. Briefly, and I have some other fun stories I'd like to share, but I'm out of time, so I won't do that. Make sure we're not assuming things. Make sure we're not acting on bias. Make sure we're not acting on prejudice. I've had some sad situations happen as a result of that, but I've also seen some funny situations happen where someone just assumed something and it turned out to be really funny. And it can be, but most of the time we need to make sure that we're not assuming things or we're not acting out of a place of our own bias or prejudice. We need to be very careful of that. I just want to recognize you for all the hard work you've got put in to get to where you are and wish you the best of luck in your career. I'm happy to talk to you anytime. I'm down in Price. Give me a call, send me an email. I'm happy to visit with you and wish you the best moving forward. Thank you.
Thank you so much, Judge Humes. Now we will hear from Michelle Daniels of the Office of Professional Conduct.
Good morning. My name is Michelle Daniels, and I am an assistant disciplinary counsel with the Office of Professional Conduct. I've been working there for about 3 years. And so if you don't know what we do, we investigate and prosecute lawyers for violating the rules of professional conduct. So today I'm going to go over kind of how our process works, what the procedure is, you know, if you should ever get a complaint so that you'll kind of know how the process works. And then I'm going to go over hopefully some tips and some ways to avoid getting a complaint in the first place. See if I could magically work. Ooh, it does work. Okay, so first off, let's go through our process and procedures. If you ever want to go look up the rules, here's where they are located. They're kind of hidden within the Supreme Court Rules of Professional Practice. But so I encourage you to occasionally go look up the rules of professional conduct. I understand they're boring to look at. It was one of my least favorite subjects when I was going through law school. But now it's interesting because rules are only become interesting when you start applying them to a particular case. In any case, here's where they are if you ever feel so inclined. And then I wanted to go over something that's, I think, still confuses a lot of lawyers. Although the Office of Professional Conduct is still connected to the Utah State Bar, we are no longer under the administrative oversight of the bar. Instead, we are overseen by an oversight committee that reports directly to the Supreme Court. The goal with that is to avoid any appearances of impropriety, basically, that, you know, somehow our prosecutorial discretion is being impacted by being directly tied to the bar. Additionally, in case you didn't know, there is a licensed paralegal practitioner program. These folks are called LPPs, and they have to follow the same rules you do. We also have jurisdiction to investigate and prosecute them for violations of the rules of professional conduct. So as a result of the LPPs becoming a part of our jurisdiction, all the rules now refer to lawyers instead of attorneys. Y'all are attorneys because you're members of the bar. LPPs are not members of the bar, and so collectively, attorneys and LPPs are called lawyers. Okay, who can file a disciplinary complaint? Anybody. Anyone. We get a lot of lawyers who get frustrated because we take in complaints from like opposing parties or members of the public. So as long as whoever has filed the complaint makes allegations that implicate the rules of professional conduct, we're obligated to investigate it. So it doesn't matter where it comes from. So be careful what you put on your Facebook page because your neighbor could complain. As far as our office can open our own complaints against you. So say, for instance, you get caught up in some kind of, I don't know, criminal enterprise and your name is in the news, we'll see you there and then we'll open up a complaint and ask you to explain what happened. Also, your IOLTA accounts, the banks that handle them are required to send us notice when your trust accounts go overdrawn. So we know if you have less than $0 in your trust account, and we'll ask you to explain that. Of course, that should never happen, but it does. So be aware of that and try to avoid it if possible. Okay, so once we get a complaint in, what happens? Initially, we do a summary review process. Sometimes we get complaints that we don't have jurisdiction over. Like if someone complains about a judge, a sitting judge, for instance, those go to the Judicial Conduct Commission, they don't come to us. Or if someone complains about a politician they may think is a lawyer, but they aren't. Obviously, we can't do anything about that. So we go through all the complaints as they come in, and we dismiss the ones that we can't handle or that basically allege nothing that would implicate the rules of professional conduct. Once it makes it past the summary review process, it gets assigned for investigation to an attorney. At that point, we will notify you that we've received a complaint. So we'll send you a letter, usually by email, letting you know that we've got a complaint made against you. This is why it's always important to make sure that your information with the Utah State Bar is updated and current, because if we're trying to get a hold of you, that's the information we use. So make sure that's always current because you don't want to miss something from us. Once we notify you that we've got a complaint, then we will start asking for information. We'll go to the complainant, we'll ask you to explain what happened. We kind of go back and forth. We'll look up court dockets if that's relevant. And then once we have all the information we think we need, we'll make a determination about what we should do with it. And we make decisions as a group to try and make sure things are consistent. So all the lawyers get together in the office, talk about the case, and decide what to do with it together. At that point, we can dismiss it if we think, no rules are violated or that there isn't enough evidence to prove a rule violation. If we think you violated a rule, we can offer diversion, which kind of takes you out of the discipline system. We'll probably have you take like some CLEs, you'll have to pay some fees or something like that. But once you complete the diversion process, then we dismiss the case and you have no record of discipline on your discipline history, which is good. If you don't qualify for diversion because what you did was, more serious, then you can stipulate to discipline. We can just reach an agreement like you could in court and agree on a form of discipline. Or if we can't agree on anything, you don't think you violated a rule, we think you violated a rule, we'll issue what's called a notice. It's somewhat similar to kind of like an information in a criminal case. We basically identify the rules we think you violated and all the facts and information that we've collected. You have an opportunity to file an answer to that. And before I get to the next step, I wanted to touch on appeals. So if I dismiss a case, the complainant has the opportunity, they have 21 days after the dismissal to file an appeal to the chair of the Ethics and Discipline Committee. If it goes up on appeal, the chair looks at the file de novo. So they don't rely on what we decided, they make their own decisions. So if I missed something, in all the facts, like if there was a rule that I didn't address in my dismissal, the chair could look at it and say, oh, well, this rule may have been violated. I'm remanding this back to the OPC. And in that case, we're required under rule to issue a notice and take the matter before a screening panel of the Ethics and Discipline Committee. I'm telling you this because I just want you to be aware, if we dismiss something, we try to really button up our dismissals. So if I go back to you and ask you for some information a couple times and you're getting frustrated and you're like, oh, the OPC, why are they harassing me about this stupid case? It's because it may very well be because I'm trying to ensure that my dismissal is going to stick. I don't want it to go up on appeal and then get remanded back to me and me have to issue a notice and take it to a hearing when I know that really it should have just been dismissed all along. So keep that in mind if you ever get a complaint and you start getting frustrated with me. Once we issue a notice, you've submitted an answer to our notice, or if the case gets remanded back to us and we issue a notice, we take the matter before a screening panel in the Ethics and Discipline Committee. So the panel is made up of volunteer members that are appointed by the Supreme Court. Each panel has 5 members. There are 4 lawyers and 1 public member on every panel. These hearings are pretty informal. Like they happen in a boardroom upstairs and we all just kind of sit around a table. There's certain formalities that they do have to follow, but they do not have to comply with the rules of evidence. There's no like cross-examination. The panel kind of can run the hearing however they see fit. The standard of proof, in case you're wondering, is preponderance of the evidence. So it's not a particularly, high burden. It's not like a criminal case, right? So the panel only has so much authority. If they disagree with us, they can dismiss the case. They can dismiss it with a caution, telling the lawyer, hey, you should be on the lookout for this. Don't do it again. They can also issue admonitions or public reprimands. So the difference between the two is both go on your disciplinary history. The facts of the case and the rules that were violated are published in the Utah Bar Journal. So if you've ever looked at the Bar Journal yet, there is a disciplinary corner at the end of the Bar Journal. When you get an admonition, your name is not identified. We'll just refer to you as the lawyer or the respondent. But if you get a public reprimand, then your name is identified and everyone else, all the other lawyers who are reading the Bar Journal will know that you got a public reprimand. So the public reprimand kind of has a shame factor associated with it. So a lot of lawyers try to avoid getting a public reprimand. But so that's the extent of what a screening panel can do. If the rule violations are more serious, then they will tell us to go file an action in district court. A court has the authority to impose more serious discipline. So a suspension, probation. Here is where we would refer to what was formerly called disbarment as delicensure, which is so much harder to say. But it's important to avoid violating any rules that get you into district court because it's always going to be more serious. So these matters proceed kind of like any other civil case. We file a complaint, you file an answer, we go through discovery. The ways that it differs is that there is no right to a jury trial. Judges obviously know the rules of professional conduct, so they are more than capable of deciding these cases. And so there occur in two phases, somewhat similar to a criminal case, where you would have an adjudication on whether or not the rules were violated. So we hold a whole trial to determine whether or not a rule was violated. If the court determines that yes, a rule was violated, then we hold a separate sanctions hearing where the court determines what sanction should be imposed. And obviously that can vary anywhere from, I'd say, an admonition. We've gotten those from a court sometimes, all the way up to a delicensure. So that is my summary of how cases work their way through our office and the process. And so now I'm going to go over, hopefully, some ways on how to avoid our office together. Okay, so I'm not sure how big that looks from there, but so this is from 2023. And oh, has that been up the whole time? Let's see, can I get rid of that? Well, in any case, shoot. Oh, well. So the largest number of complaints we get are from your clients. So bear that in mind when you're dealing with your clients. The next largest component is opposing parties. As frustrating as it can be, opposing parties have the right to complain, and they do a lot. So especially in really contentious civil cases, I would say family law cases in particular, opposing parties tend to be unhappy. And so they file a lot of complaints. As you can see, hopefully, we also have third-party claimants. So this is just third parties that are neither a client nor opposing party, but are somehow tangentially related to a case you're handling. Financial institutions, that's a pretty high percentage as well. Those are the insufficient funds notices that we get from banks. We get them rather regularly, unfortunately. Family members of clients. So this is something I think I notice a lot in criminal cases in particular, where you have a criminal defendant who is maybe in jail, and the family is trying to, work with the lawyer and be helpful and be some kind of intermediary. We get a lot of complaints from them. Same with family law cases. Family members care about what's going on in their, children's divorce cases. So we get complaints from them. Opposing counsel, we do get complaints from opposing counsel. I will say it is rarer. Lawyers don't like to have to complain about other lawyers. I mean, we just don't like to do it. But you are under obligation to do so. It's a rule. So if you see or witness another lawyer violating a rule of professional conduct, you're typically going to be obligated to report it to us. Did this work? No. There it goes. All right. So this, as I said, is from 2023. We haven't compiled our 2024 numbers yet. But so if you can see it, this shows the percentage of rule violations in 2023. So surprisingly, 8.4 is at the top of the list. And I don't know if you remember 8.4. Probably not. But so 8.4 consists of several rules. 8.4b is when a lawyer engages in criminal conduct that reflects adversely on their fitness to practice. Unfortunately, I feel like we have seen a lot of this lately. Lawyers who are being charged and convicted with crimes. That's a violation of the rules if it reflects adversely on your fitness to practice. So try to avoid committing crimes. 8.4c is another one to also remember. It involves dishonesty. So there are multiple rules in the rules of professional conduct that involve dishonesty. This is important to note because dishonesty is one of the rules that can get you even outside of your practice of law. You don't have to be just lying to the court or lying to your client. If you're lying to opposing counsel, if you're making false statements to the public, obviously we're not going to come after you if you're, telling your spouse that you didn't stop at McDonald's on your way home and you didn't eat without them. That's fine. We're not going to come after you for that. But generally, dishonesty is something that is we do not like. The Utah Supreme Court has said it's not okay for lawyers to be liars. So do your best to be honest in every area of your life. And then the last 8.4 to consider is 8.4D, which is conduct prejudicial to the administration of justice. That's fairly vague. And so usually where we see it crop up, we see it come up sometimes, like for instance, if a lawyer gets a complaint, a disciplinary complaint against them, and then they call, say it's made by their client, they call the client, they're like, hey, I'll refund you all your money if you withdraw your complaint. That is conduct that's prejudicial to the administration of justice. So you can't act in a way that will try and prohibit or prevent or dissuade someone from filing a disciplinary complaint. In court, usually this rule comes up if we have lawyers who are taking advantage of the court system by just filing motion after motion after motion and delaying cases for years for no reason. There's other rules that also apply, but sometimes it gets so bad that 8.4D becomes also appropriate. So 5.3, the fives tend to do with supervising your staff. So your staff do not get in trouble with us. You get in trouble with us if your staff does something that violates the rules. So it behooves you to make sure you train any of your staff well, that you monitor what they're doing, that they're not taking action on their own without your knowledge. You need to make sure you've got a good supervisory system in place at your firm or office to ensure that your staff are not getting you into trouble with us. 116 is another rule to remember that we run across a lot. And the two issues that I just want to address are 116 requires you to return the file to the client if they ask for it. Remember, the file belongs to the client. It does not belong to you or your firm. So if you want a copy of it, you can do that, but you can't charge them for you to make a copy for yourself. If they want a file, you have to, their file, you have to give it to them, regardless of how much money they may owe you, unfortunately. Also, 116 covers, I'm drawing a blank now. I'll move on to 1.5. 1.5 is the reasonable fee rule. And so just bear in mind that your fees need to be comparable to the fees that other lawyers in your area are charging. It's true, if you've got a lot of experience, you can start increasing your fees, but just don't. I've seen a lot of fee agreements recently, for instance, where lawyers are doing some kind of weird stuff. Like they charge flat fees every month to cover all communication. And so it seems odd, but they're charging like, say, $300 a month. And that is supposed to cover all the communication that takes place in a month. So over time, so say you've got a client that's with you for, a year. So what, that ends up being a lot of money over the course of a year. And have you really engaged in that much communication over the course of a year? I think lawyers are trying to recoup, all their costs and all their expenses. But make sure you do it in a way that doesn't raise any red flags for us when we're looking at your fee agreements or your invoicing. Okay. I'm moving on to more particular rules here because these are the most frequent rule violations and complaints that we get. So communicate with your clients. That seems obvious. We should all communicate with our clients and we all know it. But this is the most frequent complaint we get from clients. My lawyer didn't call me back. My lawyer didn't ever email me. I sent a million emails to my lawyer and they didn't respond, or they didn't tell me this, or they didn't tell me that. A lot of times they'll say the lawyers can clear this up for us. And this is why it's important to keep good records of everything you do on a case. For instance, a lot of criminal lawyers are now charging flat fees in an effort to avoid having to keep track of their time because billing sucks. No one likes to bill. Keeping track of your time is a real pain in the neck. I used to do it and I hated it. But what you need to keep in mind is that this is something that is a protection for you against your client. You need to be proactive in protecting yourself from any claims that your client may make to us, or if they file a malpractice claim. So if you're keeping good records about everything that you've done on a case, all your conversations that you've had with a client, you've got your date, what you talked about, how much time you spent on the phone, all the work that you've done, all the preparation that you've done, your in-person consultations with your clients, that stuff you can't really prove, right? If you're talking over the phone or if you're meeting with them in person, you don't have documentation that that happened unless you bill for it and put it in your billing. If, for instance, a client claims you never discussed, I don't know, a certain part of their case with them, or a legal strategy, or a downside to something that they were doing. And if you produce to us your billing statements and you have an entry that says discussed X on this date, we will take your word for it. And a lot of times in malpractice cases, the courts will too. Because that's your record of what happened. And if you keep that up regularly, that's, you know, your course of business. That's how you do things, and it becomes reliable. So no matter what fee structure you may have, I would encourage you to always keep track of your time and your communication with your clients. Another issue with communication that I've seen crop up is recently, no, I suppose it's not recent, but over the last maybe 10 years or so, lawyers have become more inclined to communicate with their clients by text message or WhatsApp for some reason. I understand that lawyers are busy. You're running from courtroom to courtroom. You're trying to get in contact with your clients, make sure that they're there. But some of the messages that I've seen aren't of that nature, right? Instead, you're going back and forth with your client via text message, discussing the substantive nature of the case. And because the form of communication is so, I don't know, it's more personal and it's less professional, I've seen it devolve into inappropriate communications, like really bad jokes, like photos. Lawyers will start sending their clients photos of things that we just kind of are scratching our head about. So I would encourage you, when possible, try and stick to email or letters, something more formal, more professional than just text messaging or messaging of some kind, because It helps you keep a line between your clients, a professional line. Sometimes when you cross over into some kind of personal relationship with your clients, it can cause a lot more problems, and it's just not worth it. So those are the things I wanted to touch on with respect to communication. All right, keeping your law practice and your personal life separate. It seems obvious again, but I am compelled to point out that your clients are not a dating pool. You may want to look elsewhere for people to date. These days, because of the nature of personal relationships, inevitably there is a trail, some kind of paper trail. So when we get people complaining, we inevitably get text messages, videos, photos of your interesting interactions with people you shouldn't be interacting with in this particular way. And it's embarrassing, not only for you, but for us. We don't want to look at photos like those. So bear that in mind as you're going out into practice. Something else to consider is that your family and your friends are now going to be like, oh, we've got a lawyer in the family. I'm going to go to them for all of my legal problems. Although you can do it and it's not against the rules, I would recommend that you strongly think about it before you proceed. It can be hard to maintain to not be biased if you're representing your sister in her divorce against her horrific ex-husband. And we've had cases where lawyers get overly involved, perhaps file some things with the court that they shouldn't, maybe say some things or take action that they would not if they weren't personally invested. And that's a conflict of interest. So same with businesses. There's a lot of, like, I've seen, lawyers involved in a bunch of LLCs with their friends or other lawyers. And then you just need to be careful and go look at those rules of professional conduct to make sure that you're not doing things that are crossing a line because you have a conflict. So make sure that you occasionally look at those rules, especially it's rule 1.8 in particular. There's a whole list of potential conflicts that you can get into. So be careful of those. Okay. I always feel like every time I give this presentation that I'm saying things you already know, but I will plow through anyway. Calendar everything. A lot of the issues we see are diligence issues. We get a lot of complaints from people about their lawyer failing to file things on time, failing to show up to court on time or at all. And presumably it's because the lawyer has not kept track of all of their deadlines, all of their court dates. So I would encourage you to look at potential software programs. There's a ton of software out there now for lawyers. And they can help you keep track of every single thing that's going on in your case, or in all your cases and with all your clients. They can help you, bill with billing, with your billing entries, your time entries. They can help you keep track of all of your court dates, all of your deadlines, discovery deadlines, what have you. If you can't afford that, then you need to figure out another way. Spreadsheets, Outlook, calendaring, whatever you need to do to keep track of all of your cases appropriately. And if you find yourself in a situation where you can barely keep up, we all kind of end up filing things at the very last minute on a lot of times. But if you find yourself struggling and falling more and more behind and you can barely keep up, then you might want to consider if you just have too many cases or clients. And that's hard to say because especially if you're out in a private practice, that means less money, right? Less income. But you also don't want to run afoul of the rules and end up in our office. So be mindful of calendaring. It's really in your best interests. Okay, trust accounts. This is important. This goes back to when we get insufficient fund notices from the banks. A lot of times it is at that point that we find out that the lawyer did not know how to use or manage a trust account. If we have to, we can subpoena copies of your statements so that we can see how you're using your trust account, how you're using your operating account. As a reminder, client funds go in your trust account. Third-party funds go in your trust account. And you should be regularly withdrawing the funds that you have earned at least once a month and putting them over into your operating account or your business account. Don't leave them in there forever. Don't, if you have some kind of business shortfall, you need some extra money to cover a bill. Don't use the client funds in your trust account that you haven't earned yet. And that's called stealing. And our Supreme Court has been very strong on the issue of misappropriation, which is stealing client funds. We have yet to have a case in Utah where we have found and proven the lawyer has misappropriated funds that has not resulted in delicensure. All those lawyers have been disbarred. So you need to learn how to use a trust account. If you're going to be managing it, there are a ton of CLEs out there. We have a trust accounting school that we offer once a year. We also have an ethics school that we offer twice a year, during which we have our trust person give a brief overview of how to manage your trust accounts. Keep track of how much money you are holding for your clients, which clients. This is where these helpful fancy software programs come in handy because they can calculate all of that for you. If you can't afford those and you're not good at accounting, maybe hire an accountant to help you. This is not an area where you want to fool around because this can really get you into serious trouble. So if you're going to be the one managing it, make sure you learn how to do that. Okay, confidentiality. This is an interesting topic only because it started taking on different direction when the internet appeared a number of years ago. That doesn't seem so long ago to me, but you probably had it most of your life. When a client posts a negative review about you or your firm online, what can you do in response? At this point, we don't have any guidance from the Utah Supreme Court on this subject, but we do have other jurisdictions who have sanctioned lawyers for getting into too much detail in their responses that they have posted in response to negative reviews. The ABA has come out with an opinion. What they recommend is you just say something like, well, we're sorry that this person feels this way, but we respectfully disagree and we would encourage them to contact us. We can't say more because of confidentiality. That way you're responding to it, but you're not revealing any confidential information. There have been lawyers who get into great detail in their responses because they're angry. They feel like these reviews are unfair. They're not right. Their client or someone else is lying, and they want to defend themselves and let everyone know on Google that, they're a good lawyer. But you need to be careful about how much information you share. You can't reveal your client's name. There are lawyers who will go into, what they were charged with, what crimes they were charged with, and, other things, what money they still owe them. And it's better to just say very little and don't get yourself into this uncomfortable situation where we may have to, because your clients will tell us. We have gotten many copies of reviews and responses to reviews from clients or opposing parties, because they also like to go post on your page, of course. So remember that confidentiality, as far as the rules of professional conduct go, is broad. It is broader than like the attorney-client privilege you would deal with in court. It pretty much covers everything. And it not only does it deal with your current clients, but you have duties of confidentiality to prior clients and also to prospective clients. So keep that in mind. And that's kind of all I had. Did anybody have any questions about anything? Nope. Okay. I think you have a break. I think you have a break next, don't they?
Yes.
Yeah. Oh, thanks. Like there's yeah. That's been up there the whole time, but I didn't know how to get rid of it.
That's a fun topic.
Yeah, it was covering. Yeah, no way.
Yeah, I know. I don't know.
Okay.
Thank you so much.
Yeah. Oh, yeah, you did a great job with all this. Okay.
Good, how are you? So we're just simply sitting so I suppose it's good so far? Cool. So I'll no, I don't know you. Okay, Jesse. No, so I understand. Yeah. It's still there. So where are you? I'm solving the Yeah, that's cool. Yeah, so it's great. Yeah. Exactly. Yeah, I can excited. Are you with That's good.
I mean, I was in first with you, our spines are. Something you could do here. Right, floating meeting. And if you need him, you just press escape.
Now I know.
Yeah.
Okay.
Small town. Say hi. The world stuff. Good. So we had our bodies and flows I'm in justice for it now. As big as standing there. It's somewhere. No, he's. No, you're talking
Yeah, I guess I could slay my friend. Second likes their sport. There you go. There you get there. If you want to, it's not because of my boss. I'm guessing, right. Oh, you're good. Yeah, no, constantly meeting people or like hearing about well, so like the next concert is just yeah, whatever you choose. So yes. No, I don't. I have like too much money to do, but that's Honestly, like, it's yeah, and I think a lot of stuff myself, at least. Wow. Right. Yeah, try you sign up for to do this, which will down to like frankly, it's
Playing by the seat of my pants today.
they're saying.
It's like to be able and there's a clicker. Has all right, everyone. I hope everyone enjoyed their break. We're gonna go ahead and get started again with the next portion of our meeting. Next, I'd like to welcome Martha Knudsen. She is the Executive Director of the Wellness Committee for the Legal Profession here in Utah.
Hi, everyone, and welcome to the practice of law in Utah. It's nice to be here today and speaking to this group. Today, we're going to talk about the importance of proactively caring for our mental health and well-being, why you should care, and also some strategies to help you do so. So a little bit of background on me. I've been a lawyer now for 25 years. I was a litigator, an eventual law firm shareholder for my first 10 years. And during that time, I didn't take care of myself. I put everything I had into my profession because I had this idea. It was kind of the prevailing, like, just underlying belief at the time. This is in 1999 when I graduated, that you could either crush it professionally or you could do well personally and be happy and all the things. And like, you know, it's sort of a trade-off. Invest in your life, invest in your profession. And so I invested all in the profession, and I did really well for a while. Until then, I crashed and burned and was burnout. And I didn't even understand what was happening to me. So about 10 years in, I like washed my hands of the profession, walked away from my partnership, and I was like, see you later, suckers. This is not for me. But that didn't last very long. I went back and I went back into the practice. I got lured back in to be general counsel of a national real estate management company. And as I did this, I was really thoughtful about not completely crashing and burning again. I'm like, is there a way that I can do really well professionally and still be there for my itty bitty kids and my husband and have a life and do things that are fun, and actually know what I like to do for fun? And so I went out and started looking. What I found was the science, what's called positive psychology. And what that is really the science of human thriving and optimal performance. And this is a study that looks at what are the strengths and capacities and resources that people have that lead to flourishing, that lead to a life well lived. And in the course of all this, I took myself back to school and got a master's in applied positive psychology from the University of Pennsylvania, where I had the great fortune to work with Dr. Martin Seligman and Angela Duckworth and some other notable folks in the field. And as I was doing all this, I realized that I had been making this false choice during my practice, those first 10 years, that it's not a either do well professionally or be well personally. It's really being well and taking care of ourselves proactively is what drives our ability to do well, especially in situations like the practice of law, where it's challenging, you deal with high stakes problems, there's a lot of stress, right? So all of those things, people perform better in situations like the practice of law if we are thriving. So this is now here today. I get to work with at the intersection of both these things. So that's how I am where I am, because this is a very personal thing to me. And I wish that I would have been given resources when I was a brand new lawyer or a law student. So it's really great. The Utah Supreme Court in Utah is really trying to do it differently for this new generation of lawyers. So as we go through this today, I welcome questions. If there's anything that you don't agree with or you want to ask about, please do so. I'm really informal. And as much as you'd like this to be, we'll have a discussion. Okay, so First, I want you to think about what's the first stuff that pops into your head when I say mental health. Call it out if you feel the need. I welcome that, actually. Depression, okay. Yeah. What else? Yep. 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 Anybody else? All right, these are very common responses to that question. You know, what is mental health? But I'm asking, like, I want you to think about today, like, why is it stress, anxiety, depression, those kinds of things? When I ask you to think about physical health, you're not going to yell out cancer, diabetes, broken limbs, right? Because physical health is a spectrum and mental health is the exact same way. All those things that were called out, that is a part of mental health, but that is mental ill health. Mental health is all the best things about being a human being. It is the positive emotions that you feel. It's the accomplishments that you have. It is the relationships that you cherish. It's the wonderful experiences in our life that uplift us. All of those things are part of our mental health too. And here's the thing. If you are a human being, you have mental health. You have it all the time and you do not get to opt out. It is part of the human condition. So mental health really is a spectrum. And it's everywhere from like this here, from thriving to surviving and everything in between. And we sit on this spectrum all the time. And where we sit changes a little bit, you know, day to day, over time, depending on what's happening in our lives. It also has a lot to do with our small habits of thought, of how we manage our emotions, of interactions with others, of the environments that we're in. And these are mostly little tiny things that are just part of how we live that influences our mental health and can help us either, you know, maintain positive mental health or move towards flourishing. Or on the flip side, if we're not paying attention and we're not proactively caring for ourselves and building these little micro habits and micro moments that help us stay healthy, we can end up on the barely surviving end of it. The thing is, it's not neutral. You can't just be like, oh, I'm fine, right? Because what happens when we're in that, I'm fine, it's like that kind of meh feeling, you know? Does anybody get that? It's like you're not crushing it, you're not loving everything that's happening, you're not thriving, but you're also not struggling. You're just kind of like, we all get in that place. But the thing is if we live in that place, data tells us that we are the most likely within the next 10 years to be on the barely surviving end and develop a lot of the mental health concerns that you see in our profession. So that's what we're talking about today. So when you hear me talk about well-being, it really is a continuous process toward thriving. It's something that we work on all the time. It's those little micro moments. It's not like one day you're all of a sudden going to unlock well-being and, you know, unlock happiness. You're like, I have arrived. This is it forever. No, this is something we work on all the time. So where we sit on this scale really has a lot to do with things that we care very much about as people and as lawyers. So, you know, that whole being well drives doing well. These are the correlations. When we're doing well, we are more likely to have better physical and mental health. If you're in an organization, you're less likely to leave that organization. You're going to like your job more. You like what you're doing better. Your brains work better. Like our brains are our money makers in the law, right? So we want to keep those healthy. And if we're thriving, our brains work better. We're more creative. We perform better. So all the way around, we do better in the profession. We're more likely to do better in the profession if we are thriving, right? We handle the stress of the profession better and all those things. And here you see in bold, greater professional identity. So that is a sciencey way of saying civility and professionalism. It's easier for us to approach the practice in a way where we're civil to the others that we work with, that we're professional and all those things if we are doing well. So the Utah Supreme Court in 2023, they're like, yeah, this is really important. They had already launched a task force starting in 2018 on lawyer and judge well-being, and this is now codified as part of our duty of competence. Comment 9 reads that lawyers should be aware that their mental, emotional, and physical well-being may impact their ability to represent clients. And so we really, something that the court's like, yeah, we need to take care of ourselves. So any of you follow sports? Yeah, I see a lot of nodding heads. Any of you follow like performers, athletes, like dancers, musicians, anything like that? Like sports, performers, all that? Okay. What kind of coaches do they have? Like what kind of things do they do to make it so they can perform at their highest and best? Like in the best way that they can. You want to call it out? Yep. What kind of trainers?
Personal trainers.
Yep. How many of them do you think have sports psychologists? Yeah, to help them stay mentally fit, right? And how many of them do you think as soon as they're like hitting a glitch, suddenly their putt is off, or, you know, they like Simone Biles got the twisties or whatever in the 2 Olympics back. What do? They go when they get help and they recognize it and they're like, yeah, something's off. I have got to address this. So they do a lot of things to keep themselves fit, beyond just the physical self, right? They're really also looking at their brains. And so you as lawyers, you really are very similar to an elite athlete or an elite performer. It's what we do. Yeah, we might not be out there, you know, on the golf course or in the football field or on the stage, but you are very like athletes and performers. And so it's incredibly important for us to take care of ourselves. So what happens when we don't? What does that look like? Well, it could be stuff that's going to get you in trouble with the OPC. Like you start ghosting your clients. You don't return phone calls. You're not calling opposing counsel back. You're blowing off work. You're missing deadlines. You are commingling funds maybe because you get yourself in a tough spot. So a lot of these things come after like those small micro moments you find yourself in this place. And we don't do it because suddenly, I mean, I don't think anybody, hopefully, that's ever like graduated from law school has thought, you know what I can't wait to do as a lawyer? I cannot wait to commingle funds. And like, that is like what right? You slowly get there. And then it seems like the only way out. And a lot of that times that has to do with the fact we're not taking care of ourselves. You guys are athletes, you're performers. You have to take care of yourself so you don't end up in that place. But that's what that looks like in different ways. Or you could end up just being a complete ass to all the people that you're around, which sucks for you and sucks for them. So, okay, you're in the practice of law. It's going to come with stress, right? There are things that we do that's the topic of a whole other session that we create unnecessary stress for ourselves and others in the profession. And like I said, like, I can't even go on that tangent, but the profession comes with stress that right now we can't get rid of deadlines, the oppositional nature of advocacy. Sometimes, you know, there's things like that that come along with it. High stakes matters. So this is what we do. We get in, we're in the groove of work, and something stressful comes up that's demanding. And you're like, it's my job. I'm in charge of this case or this matter. I have to deal with it. And so you do what we all do. You know, we're all little achievers here. We put in the work. And a lot of times we blow off taking care of ourselves in favor of, you know, putting in the work. And then we either get a payoff, you know, like, oh, sweet, that really helped. I didn't sleep for 3 nights. Awesome. And look, it turned out really well. Or else you don't get the reward. And then you're like, okay, next time I have to go without sleep for 4 nights to get this done. And then the pattern gets reinforced. So that's just the way we operate, right? Those little small things we do every single day. But the reality is that we can't keep this up for very long. without crashing or, heading down towards the barely surviving. So it's really important that we understand what's going on and proactively build into our lives, our daily lives, our weekly lives, things that help us to take care of ourselves, right? So let's talk about what some of those things are. Well, first of all, this is a lovely quote by a colleague of mine, and I didn't put the close quote on the end. See, this is where I get on myself. I'm like, everything else is good, but it's the one missed quote. Anyway, so Heidi is a law professor, lawyer, and an incredible author. She writes about lawyer well-being. I highly recommend you pick up her book, The Flourishing Lawyer. It is by far the best book on this subject that's out there, and her writing is incredible. But really, this is what we're talking about. How do we take care of ourselves and each other in a way that we can tackle the hard things about this profession instead of crumbling under the pressure or getting sick? All right, so what do we do? Now, Dr. Martin Seligman, he is kind of the founder of a lot of this well-being movement that you hear in all different places. And he has, this is his construct for the building blocks of flourishing. So this is just focusing on the individual, right? On what you can do yourself. And I want to make it very clear as we look at this, that the importance of the collective that we're in, our organizations, our cultures, our communities, they have a very big impact and responsibility when it comes to, our health, right? But today, I just want to focus on things that you can do. So Marty, with all of his research, he's really looking at what are the things that help us to thrive. So it's not just if we get rid of the things that we don't want, which is where psychology has mostly been focused. We don't want to be depressed. We don't want to be anxious. We don't want to have insomnia. All those things, at best, you just get to neutral. The things that help us build a life worth living and help us to flourish and stay healthy, and actually also buffer against some of those things, are different. So this is Marty's construct. And quickly, we've got the P's, so PERMA, V, so positive emotion, engagement, relationships, meaning, achievement, and vitality. These are all aspects of what we know help us to take care of ourselves, deal with the tough things about a stressful profession like law, and love what we do and enjoy our lives and stay healthy. So we don't have a ton of time. I'd love to dive into each of these things, but you do have this handy dandy little sheet. And so I'd like to go through an exercise and you'll also get these slides so you can read more detail about each of these things and reach out to me for more information about them, because there's a ton of stuff within these things. But the idea basically is these are all different buckets, different domains of our life that we want to pay attention to boosting those things, right? Because they all have positive spillover into the other. And the research shows that the more we are doing well in each of these domains, the better that we are doing overall. So oftentimes in law school or in the practice of law, a lot of our bucket is going to be full of achievement. We are achievers, which is great, but sometimes it's at the sacrifice of the other things that help us stay healthy and make a life worth living and put you up on that end of the scale where your brain works better. Okay, so here's the exercise. You got this little sheet. And this here is a wheel that has each of these different domains on them. So what I would like you to do is take a minute and get out a pencil or a pen or whatever, and go through each of these domains and think about your fulfillment level in each one, right? 1 being not fulfilled, 5 being extremely fulfilled, and then draw a little X mark on whatever number you see there. And just a note with the positive emotion part there, that is not fake positive emotions. That is when you authentically feel happy or calm or peaceful or proud or awe or any of the emotions that are like feel good, right? It's not a slap a smile on it and pretend you're happy. All right, give it another minute. See, people are thinking. John, what do I have? 5 minutes left? 6. Okay. All right. So some of you are still working on it and continue to do so, but when you're done, take your pencil and draw a circle between each of those sections wherever the number is, right? Like starting with positive emotion, whatever you put the X, draw a line from that to the X in engagement and so on and so forth until you come back to positive emotion. And that is a way to kind of take a look at where you're balanced. I don't love that word, but like, are you really putting all your eggs in one basket and not taking care of the others? For me, when I burned out, my achievement was through the roof and my health was as well. I'd work out and I would go to the office and bill, you know, but the others were sadly lacking. Had I done this at the time, I did not know something like this existed. So this is just a way for you to take a look and see maybe there are areas in your life that you need to attend to, you know. Are you feeling much positive emotion these days? Are you do you find what you do meaningful? Are you moving your body? Are you eating? Are you sleeping in a healthy way? Are you engaged? Right? All these things it's just something to think about. Like, where's your mind at? How's the self-talk? Is it negative? Do you have that critic on your shoulder that likes to tell you that you're dumb and that you suck? I do. This is something I've had to work on majorly. And if I'm not taking care of myself, that's one of the first signs is that critic sits on my shoulders and starts to tell me all the ways that I have messed up my life or doing something wrong. And 95% of what it's saying is lie, right? Because your brain lies to you. So, you know, think about those things in your life and take a minute to reflect every day on this stuff. Check in. And see how you're doing. And there's really ways for each of these here to boost those for yourself. And as the Wellbeing Committee, we're really trying to put that information out through our programming and the rest to help us know how to take care of ourselves. Because sometimes when I talk to groups and you talk about well-being, I get that, well, I don't have time for that, right? Like, it stresses me out. Worrying about well-being makes me more stressed. And that's not the intent. Remember those little micro moves that lead us up or down? It's just really learning how to incorporate some of these things that really matter into our daily lives that become part of how we work, how we interact, how we talk to ourselves. Are we building things into our lives that give us a boost of positive emotion? Those kinds of things. Like, are we taking time to let ourselves recover from stress, or do we live there? And so, you know, once they become habits, it's not really, other than exercise and sleep, it's not going to tack on a bunch of extra time in your day. So that's what we're really trying to get at, is the proactive attention now to this kind of stuff. Because that's the thing, is at the time when you're doing great and you're loving the profession, when you enter, oftentimes that's when you're like, I'm fine. I don't need to do this stuff. That was me. Like, this is great. I love it. I can work all the time. I'm so excited about my life. But then little by little, right? The not recovering from stress, not doing all these things will wear you down. And then you end up like me at 10 years in and walking away from a lucrative partnership because you just can't anymore. So please keep that in mind. Take care of yourself. Okay. And consider the environments that you're in. If you are working in a place that is toxic, start looking for another place to work. That's the sad fact, but it's very important. Okay. this is the whole thing about like, this is not just on you, our environments, our organizations, our profession we have a duty to you and to each other, right? That's a topic of another conversation, but I just don't want you to walk away feeling like it's all on you. Okay, this here is going to be in your materials as well. Our bodies and brains are incredibly intelligent. These are things that start to pop up when we aren't taking care of ourselves or we're in a situation that is not good for us. Okay, this is like the check engine light in your car. We all have some. Mine, I get really anxious. I am super cynical and I don't want to be around anybody. Right. So those are kind of the ones when they start that in my critic I told you about. When that starts up for me, I'm like, okay, what am I doing or not doing that I really should change? Okay. So also the Utah Bar has resources for you at no cost to help you thrive in the profession, handle the stress of it. So sometimes, just like an athlete, you need help. You need to talk to somebody, something your putts off, right? We provide you with access to high quality mental health services through a company called Tava Health. Every year, the bar allows for 6 no-cost sessions with a therapist. You get on this website, your name's already uploaded, so you can get on if you want to use it, set up your own account. I'll never know who does it. We don't. We just have like aggregate numbers. This is going like gangbusters. Lawyers are using this a lot, which is really awesome. I go to therapy. I've gone off and on during my life, and it's super helpful. It helps me stay sharp. So you get on there, you set up an account, you can put in, like they'll have a little assessment to kind of give you an idea or them an idea who to place you with. You get to pick gender, issues, modalities, whatever. And then you get a list of therapists and you get to pick one. You pick it, that person, their availability is on the screen, you schedule it yourself and boom. And if you use your 6 in a calendar year, which we hope you do, you can continue on with the same therapist or another therapist through Tava. And it's either $125 cash pay, or they take your insurance, most insurances that we have here in Utah. So it's awesome. Totally confidential. Bar never knows who's using it. Therapy is incredible. Just like high performance athletes, right? It's a way for us to stay sharp and get out ahead of stuff that we see coming down the pipeline for us. So please use that. Also, we have what's called Lawyers Helping Lawyers, and this is a confidential peer-to-peer mentoring organization. And how it works is if you're having a hard time about whatever, a lot of times people think of substance use with Lawyers Helping Lawyers, and we do that for sure. But it's also anything you're struggling with. I've worked with people that are having a hard time with stress or dealing with a really challenging person in their professional life, or we have people that have called in because they are dealing with an eating disorder or grief, they lost a family member, whatever it is, we have volunteer lawyers to talk to. So you call in, leave a message or send an email, and typically we are able to get back to you within 24 hours. You get assigned a volunteer and you just work with each other. 100% confidential. This is not something at Lawyers Helping Lawyers. We don't even keep lists of the people that reach out. The only people that are going to know who you are is the person answering the call and the volunteer. So please use it. It is so incredibly helpful if you're having a hard time. I highly recommend it. And there you have it. So that's a lot of ground in a little bit of time, but thanks for your attention. If you want to learn more, that's the link to our part of the website, or just check us out on the bar's website, and you can also email me at the email below. And I am a member of Lawyers Helping Lawyers. I'm on the board. So what happens when you talk to me stays with me. So, please reach out with anything you might need. All right, thanks.
Thank you so much, Martha. And just a point of like clarification. So the top is, it resets in February? Is that
It
correct?
resets on February 1st.
February 1st.
Yeah.
So,
So, get on the bandwagon and use those 6.
yeah, if you haven't used your 6, you could get them all in by February.
Yeah.
Like, yeah.
Yeah, and it's really easy to get in. The longest wait time I've heard is 5 business days. And that's huge right now. If anybody's tried or has a family member that's tried to get in and talk to somebody, the waiting lists are long.
Yeah.
So,
So,
it is.
so I would encourage you to use it. I've done it and it's incredible. Even my wife is also an attorney and she understands it. We understand it, but there's sometimes things in your life that even having 2 attorneys, like you just don't want that to put that onto your spouse or family. So that's a way, that's not just what counselors are for, but it is a place to get things out there that you need to get off and be able to focus on something else. So it's a great resource.
Yeah, having somebody to talk to that has no skin in the game, is really nice. So, yeah.
Yeah, thank you so much,
You're
Martha.
welcome.
And we'll now hear from Megan Conley, who's over the access to justice.
Good morning. Martha is so lovely and wonderful and amazing, and I hate going after her, so you can leave. I'm really grateful for the invitation to be here today with you all. My name is Megan Connolly. I'm the director of the Utah State Bar's Office of Access to Justice. So we're gonna walk through some interconnection, I think, with what you'll see around well-being and how pro bono can actually be additive to your practice and to your mental health. And actually how to avoid ethics and discipline, I think is coming up after me. So it's a good sandwich. Goals for today then are really, I hope this is informative. I hope it might pique your interest in pursuing some of the volunteer opportunities through our office. And also, if you're at Thanksgiving dinner and your cousin's girlfriend asks about a divorce, I'll have referrals for you through this. Okay, so roadmap for today, I'm gonna do a high level overview of our Access to Justice office. We'll cover the rules and ethics concerns when doing pro bono. We'll run through some different pro bono opportunities with a deep dive into a few of those, and finally get into the why, other than do-gooding, that pro bono matters and is impactful for attorneys. Cool. So this is our reason for existence with the Access to Justice Commission. We're a statewide body, kind of the governing body for our office. Most states have some version of this, whether it's in the courts through an Office of Justice Initiatives or an Access to Justice Commission like ours, which is kind of multifaceted with the partners and actors. Like I said, we are part of the Utah State Bar. The commission then is the body setting priorities for us and includes members of the private bar, the judiciary, the governor's office, legal service providers, and community-based organizations. And this mission statement here is our reason for existence. Equal justice under the law is really just a fallacy unless we work towards ensuring that even the most vulnerable members of our community can access our system and have meaningful advice or representation in it. Before I kind of get into the how, here is the why. It's an equity issue. Utah, we're not unique, but we have an alarmingly high number of legal deserts. So Salt Lake County, we're pretty on average across the nation, but you will see we have some counties where there's 1 attorney, 2 attorneys, or none. Supply is nowhere near demand or need. And this kind of outlines it even more for you. You can see we have 29 counties, 16 of them have 10 or less licensed active attorneys. For the counties that might have 1 or 2, the attorney might be a prosecutor. So not super helpful for constituents or community members in that vicinity. Populations also don't correlate with land area. So this does not include whether, like, if it's geographically accessible or if it's affordable for people throughout the state. We are not going to volunteer our way out of that predicament. I'm well aware of that, but pro bono is certainly a tool in our toolbox that we are using to hopefully improve equity and fairness and accountability in the courts and access for folks who otherwise wouldn't have the ability to speak with a legal representative. So unlike other states, like pro bono is not mandatory here. It's aspirational to do 50 hours a year. But do-gooding, you can also reap the benefits. You can get CLE credit for your pro bono. You can get 1 CLE credit for every 5 hours donated through pro bono service. Our office also does pro bono, kind of intro to pro bono trainings that include that elusive ethics credit. They're typically free. And so at the end of this, you'll see my contact information, or you can go to our website and see when our trainings are, if they fit with your schedule. Most of them are hybrid. And we encourage you to seek us out as a resource for meeting those requirements. So licensing isn't coming after you at the end of the year. This is the dry part. Our courts are really quite forward thinking. Utah was one of the first jurisdictions to have unbundled services, which means you can come in and be an attorney for only a very specific like time or matter or place. So perhaps you're only doing a notice of appearance to do a court appearance for one child custody hearing, or you are filing a will and that is it. So you don't have any sort of commitment beyond what is agreed to with the client, and it can be limited based on what fits your availability, time, and also meets the needs of the client as well. This is one way of kind of addressing the affordability gap and also the lawyer deserts that I referenced earlier. The ethics thing here is the limitation must be reasonable under the circumstances with informed consent of the client. And you'll see with our office, a number of the programs that we run are limited scope in nature, and there's a standing order from the court, which already has it in place. So you don't have to put the onus on you to get that in writing or kind of convey that understanding to the client. It's done by our office and the court itself. So this is around kind of conflict checks too. In terms of ethics and conduct, certain aspects are relaxed due to circumstances and in theory not to the detriment of the client. We do a lot of brief advice clinics where if you are participating in that, it is literally just a face check. If the person sits down in front of you for the 30-minute brief advice and you know it's not a conflict, great. This will not supersede if you are at a firm or you have your own standards that need to be met. But in terms of the bar and the ethics, you're good so long as like they meet the face test, that you know this isn't a relative, that you know this isn't an adverse party from a representation that you have done previously. This is the limited appearance piece. Typically, before commencement of limited appearance, you will file a notice of appearance. If you were doing your pro bono through our office or one of our signature programs, this is done for you. So you don't need to worry about ending up in an appellate case 2 years down the road because you're the attorney of record. We make sure that this is done and that it is understood by the client and you as well, that the representation is limited in nature and only for a finite time. Also, 2 opportunities for when you make a lot of money and you retire, you can also continue to do pro bono representation through our office under Rule 14803. And if you're at a firm and you've got summer associates, perhaps this is a way under Rule 14807 for them to get some experience in court or doing motions practice. They are able to do pro bono through this rule so long as there's a licensed supervising attorney. So our office, one of our main responsibilities are signature programs. So we staff the statewide pro bono commission, which authorizes the signature programs, which receive secondary liability and malpractice insurance through the bar. This is one of like my favorite ways or conversations to have with new lawyers or lawyers in general. It's basically asking you like, what are you interested in? Because I guarantee that we will have something that will kind of hopefully meet either your interest or skills that you have or skills that you want to develop. And you can see we have brief advice. Those are typically 30-minute phone calls or perhaps answering emails on a web-based platform. We have the limited scope representation, which typically is in district court for either housing or debt collection or family law. And then we have full litigation cases as well. We had a lawyer reach out last week, very strong interest in animal rights. And we happen to have a full litigation pro bono case around animal rights. So don't think it's out of the question. If you want to do good and you want to make it something that either helps you build your skills or an area that you're really passionate about that might not fall within your tax practice or something else, reach out to us and we will do our best to meet that need. These are the signature programs that we currently have. We have 13 of them. Each one of these programs has a signature lead. So they're the subject matter expert. So we work with Catholic Charity or Catholic Community Services or NOMAS for the immigration. We have young lawyers who runs the Wills for Heroes. So when you sign up to do one of these programs, you're going to be prepared and hopefully also offered a mentor as well who can show you the ropes or answer any questions that you might have about the program itself. Our office manages the pro se debt collection calendar here in 3rd District. And I'm going to delve a little deeper into those two, along with 2 other brief advice opportunities with the ABA's Free Legal Answers and the Virtual Legal Clinic. So Free Legal Answers, this is actually a project of the American Bar Association. 48 territories have this. And like I said, this is brief advice. This is one of the strategies and tactics that we are really using to address some of the geographic legal deserts that I mentioned earlier. So the ABA does all the vetting to make sure that respondents are income qualified. They pose a question on this portal. You create an account, you log in, then you can peruse the different categories to say, I'm interested in doing family law. The questions are there. Clients can upload documents. They have already signed the waiver as well, that it's only brief advice, that there's no existing or ongoing attorney-client relationship going forward. And like I said, your commitment is really just going onto the portal, choosing a question, doing the best of your ability to answer it or make a referral, and then you're done. So the site is abafreelegalanswers.org. You would select Utah, enter your information. We approve your registration, and then you can log in and choose questions. You can see there's a myriad of categories here. The top ones that we get requested are family, housing, or other. Other is really typically consumer or debt collection. We do our best here, but we have about a 58% answer rate. So there's lots of questions in the queue. If this is something you want to kind of explore or dip your toe into the pro bono world, this is a great kind of low risk, high reward opportunity. We've had 82 volunteers last year who volunteered. These are some of the sample questions. So you can see it might just be sending the individual a referral to the self-help center at the state courts, or sending them a form, or perhaps answering a question to the best of your ability. Like I said, this is a really important tool for us in reaching folks who otherwise wouldn't have access either geographically or by the means to afford an attorney. You can see we are getting to some of the legal deserts that I had mentioned earlier with San Pete County, I think Emery County. We're doing our best to kind of spread the word with the community and like the human service providers out in those areas to get folks to submit questions here. And then hopefully we can find brilliant legal minds like you all to answer the questions for the respondents. The virtual legal clinic is very similar to the free legal answers, except it's more along the lines of it's a brief advice 30-minute phone call for the most part. If you would rather do it via email, there's that option as well. Again, this allows individuals to reach out to the bar. There is no income requirement for this. So anyone basically, as long as they're a Utah resident or have a Utah issue, can access this program. We had over 1,200 folks who were serviced through this last year. You can also see the themes continuing around family law, criminal law pops up in this one, housing, debt collection, and employment being the biggest areas of need for questions being submitted. Both of these, for the virtual legal clinic and the ABA free legal answers, we're doing a partnership with the U, SJ Quinney. We're doing monthly power hours, we're calling them, where we can pair licensed attorneys with law students who are practicing under that 14807 rule to provide the brief advice to clients. So if you're interested in doing that, it's like the first Monday, of each month is the free legal answers. And then the virtual legal clinic is based on your schedule. And that's what's great about both these, is that there's no set time for it. It's totally what fits with your schedule. If you want to be a hero and set up a free legal answers event with your firm or your affinity group, I'm super happy to facilitate that. And we can get you some CLE credit for it as well. The Debt Collection Pro State Calendar is the signature program that our office manages and staffs. When I mentioned the legal deserts earlier, I would call the debt collection or consumer law like a legal vacuum. It's not naturally occurring by geography. For the debt collection and consumer law, it's by far, you've got 80,000 cases in the state filed each year. About 98% of those folks are self-represented. The cards are stacked against them to begin with. And this type of program is really critical to help with people understand the process, engage in dialogue, to hopefully negotiate a settlement or payment plan that works with them, to give them a viable financial path forward, and also expectation management. So this is where we do have a standing order from the court for the limited scope appearance. It's Judge Paul Parker. How this works is basically anyone who answers a debt collection case in Matheson has the opportunity to have their case sent to Judge Parker's court. And once it gets sent to that court, they can ask for representation. And that's where we do our best to recruit volunteers each month to provide the limited scope representation to the respondents. We do have whole CLE training on this. We have a mentorship program for it. And our office, we think of ourselves as the subject matter experts. So if you have questions, you can always reach out to us as well. So we have a relationship with the court where we help manage the calendar. So we are able to see the cases, we summarize them, we do a call for volunteers. We're able to then make assignments based on either skill or interest of the attorney and place them with a client for the Wednesday afternoon hearing, typically that is on Judge Paul Parker's court. Most cases are brought by the plaintiff. It's so rare to have respondents engaged that most of the cases on our docket are pretrial conferences, where it really is just an opportunity to see if there is a negotiation possible. Again, most of these folks just want to be heard. And if you are a new attorney and want the opportunity beyond motions practice, like to get to argue, we do have a number of opportunities with objections to garnishment or MSJs, motions to set aside that can give you that experience to argue before Judge Parker, who is so lovely and wonderful and great. Representation matters. I'm gonna be very quick through this. You can see most of the cases on our calendar are dealing with housing. About 40% of the cases are housing debt. About half of those, there's already been an eviction. The other ones are general consumer, so credit card debt, student loans. We're beginning to see medical debt is a big one. People have $70 COVID tests that end up being hundreds of dollars because of fees and interest. And then the other tends to be like criminal restitution, auto is a big one, childcare, and professional and state and federal taxes. You can see it's for folks who don't have a lot of means, it's a lot of money. Housing again is by far the largest, about $2,500. I should say the other is kind of skewed because of like the restitution of the taxes that can't be expunged or discharged through bankruptcy. And representation matters. I mean, last year we saved respondents over $500,000. And it's really a win-win situation. I think at first the plaintiff's bar for this, the consumer law folks weren't necessarily thrilled, but in the end, like 82% of our settlements are being seen through to payment. So they're getting paid and they're not having to chase down respondents or employers around garnishments. And for the most part, like it's valid debt. We're not seeing a ton of bad debt. So I do think it's a really success example of how limited scope benefits folks who otherwise wouldn't have right to counsel or opportunity to have counsel. And it's been great for the profession as well. So there's just more, I'm really trying to sell this. I think you all should volunteer on the debt collection calendar. The garnishments are huge. Garnishments in Utah, there's no hardship exemption. People are losing 25% of their paycheck. Interest rates are incredible. I had a client a couple weeks ago had a $6,000 loan for a car that was now over $34,000. And maybe the answer there is just counseling them for bankruptcy, right? But at least they've had that understanding or the chance to be heard and feel like they can move on to the next step for whatever that path may look like for them. But there's benefits for you. So you are being a good human, you're reducing stress for your client, you're providing understanding, avoiding defaults and garnishments is super critical, and achieving a better outcome for all parties. So Wednesdays, 2 p.m., Judge Paul Parker. You can email our office if you want to get put on the volunteer outreach list. And like I said, we also have a CLE and mentorship program as well. We do have a couple firms each week. So if you're at Parsons or Curtin, they are on the calendar each month. If your firm is interested in doing that, or if you want to sign up, like, you know, we know to reach out to you the third Wednesday of each month. We'd be endlessly grateful to you. This is our Utah Pro Bono portal. It's through Paladin. So this lists all of the signature program opportunities, which are then eligible for the CLE credit. If you are interested in more along some of the training opportunities, the ethics training that we do, please reach out directly to us and we can schedule that with you. Quickly tying to the belonging and well-being. No notes. It's not just about altruism, but it will make you feel better. I promise. Wednesdays for us are very long, but it's always a satisfying day after some bad words might be said. You can also make new friends. I think as a young attorney, you know, this volunteering is one way that organic networking just happens. You're going to find folks with different and diverse backgrounds, but might have the same interest in you in a passion project or just wanting to make Utah a more equitable place. So you're finding like-minded individuals, you're doing good. And it can be lonely when you first get out there practicing or feeling that it doesn't have to be always adversarial. So you can be in community and find belonging with your peers through the pro bono opportunities that we have. I should also say it's good for the brand. I know that's not why we're here, but it could be great marketing for your firm or yourself as a solo practitioner, just to show the empathy and humanity in your practice as well. I won't divulge this, but I do have a judge who has told me before that if it's a close decision and he knows the attorney from a volunteer historical background context, he tends to rule with that attorney. So didn't hear that here, but that has been said to me on the side. And again, you've seen Utah is such a rich state. We are such a wonderful, tremendous culture of service and giving, but it is not reaching all corners. And we are not going to be able to volunteer our way out of this, but it's a great way to contribute to really community-driven solutions with folks that are in the grassroots. Shout out to my legal service and public interest attorneys that are here who are doing this work every day. But it's a great way to make a difference, make an impact in your state. Couple testimonials. It's refreshing to the soul. But in all honesty, whatever reason you choose to do pro bono, it's the perfect reason. So don't be scared, don't be apprehensive, because perhaps it's a new subject area or you're afraid, or perhaps the client engagement makes you nervous. We have a ton of resources and we can handhold you through this or connect you with other attorneys that have been doing this for a very long time. Thank you. So the Paladin is the pro bono portal, and you can reach out to our office for any sort of training, or if you have ideas on starting new programs, we're always open to that too. Yeah, thank you. Thanks, John.
All right, thank you, Megan. And now we will hear from Beth Kennedy, who is over the Ethics Assistance Committee of the Utah Supreme Court and the Ethics Hotline.
No. That's half true. I used to be over the ethics hotline. I'm not anymore, but I'm still gonna tell you about it. That's my only purpose here in these like 10 minutes I have, is to get you to call the hotline. So why should you? Because you don't want to go to OPC. And I think I heard them speaking down here earlier already. I hope that's the only time you ever have to see them, right? If we all do this right, you will never ever have to even think about them except for in CLEs. So, well, I'll go back one. So I am the chair of the Ethics and Discipline Committee of the Supreme Court, which is on the disciplinary side of ethics. But last year I ran the ethics hotline, so I'm speaking from that perspective. So if I say we, I don't mean any disciplinary authority, I mean the ethics hotline. So here's how you get to us. I'm gonna show you this a few times. I don't know if you're gonna write it down, but it's gonna be burned into your memory. This is the most important thing I have to tell you. So the bar and OPC, yes, we're in the same building. They're down here, we're up there. But we are not the OPC. So OPC is over the disciplinary stuff, totally separate from us, right? So we're the bar. We're about licensing, helping lawyers. We are serving the public and serving you. You pay us to help you. OPC is the disciplinary authority, right? Totally separate. They're about prosecuting you for ethical violations. Totally separate. And I just need you to remember that, because when I was coming out of law school, I don't even know how long ago it was, the ethics hotline used to be run by OPC. And that's weird, right? Because it's like calling the police on yourself and saying like, hey, I have these drugs, is that cool? Like, no, that wasn't working. So I just really want to be clear, these are separate. What it means is we are never, ever, ever going to tell OPC what you said. It's completely confidential, right? So please know, I just need to drill this into, we are totally separate, totally confidential. So why should you call the hotline? The first reason is because it's actually very hard. And I know you all just took the MPRE, most of you just went through legal ethics and it's kind of fresh in your head. We have lawyers calling us first year out of law school and lawyers 30 years out of law school. It is hard. I mean, some of the questions they come up with, I can't even answer. It takes, lots of back and forth and collaboration. I mean, some of the ones that come up most often are conflicts, right? It seems pretty simple, but think about when you represent, let's say you're at a firm and the insurance company hires you and you're working on defending this case for a doctor. And then all of a sudden you start to kind of feel like the doctor's interests are starting to come up against the insurance company's interests, but you're being paid by the insurance company and that's your only contact, but it's a mess. There are lots of different ways that sort of conflict can come up. What do you do when your patient dies? Or your patient, I'm thinking about medical now. When your client dies, right? What do? You have their money, you have their confidential information. Who can you tell? So they're hard. And it's time consuming, right? So this is all I think about all day, every day now. And so a lot of the times, yeah, I can answer a question within, 15 minutes. Some questions, it still takes hours. And if it's going to take us hours to figure out the answer and find the right opinions, I assume it's going to take you a bit longer. And who's paying you for that, right? If you're working on a particular case, you can't bill the client to find out if you have a conflict, right? You can't bill your dead client to find out where to put that client's money. So don't worry about it. Just call, email, get some advice. Here's another reason, is because the rules aren't stagnant. The actual rules of professional conduct themselves change at least a couple times a year. I think by the time the printed book is out, it's already outdated because that rules committee is just constantly updating. Ethics opinions come out at random times throughout the year. Supreme Court opinions changing the law for Utah comes out random times during the year. So I don't think that any of you want to be an ethics expert having to be on top of all of that in order to just do your job. But it is our job, so we will stay on top of it. And so when you contact the hotline, we'll have the most up-to-date opinions, case law, answers, whatever you need. And I mean, that's where I started. Like if I got a notice from OPC right now telling me that a client filed a complaint, I would still probably throw up. Right? Even though I am here every day and they're very nice people, like just the idea that your livelihood is being threatened is terrifying. So if you see something coming, get some advice on the front end, call the hotline, and I would tell people, lawyers a lot this on the hotline, and I'll mention it here. There's like the right thing to do and the ethical thing to do. And there's what's going to keep your client from complaining. And they're not always the same, right? So you can be doing the perfect ethical thing and your client could still file a complaint against you. And so sometimes the idea is, okay, how do we follow these rules and keep the client happy so they're not going to call OPC? It's free. You're already paying for it. It's included in your dues membership. So why not? And again, it's confidential. Even within the bar, we can't talk about it, right? It's just the hotline. So I can't tell John that you called. I can't tell John anything about the contents of the calls. No one knows. At most, we might ask someone, hey, so what's the rule on this thing? We're never going to say your name. We're never going to give any information that'll link it back to you. Okay, I want to talk really quickly about what we can do and what we can't do for you. We can give advice. We can't give you a binding legal opinion, right? So if you email with a problem and we say, okay, here's what I think you should do, and then you do it, and then your client gets mad and files an OPC complaint, OPC comes after you, our email is not going to protect you, right? If OPC thinks you did the wrong thing, us saying it is not going to get you out. But it will show that you tried. And hopefully in the email, we're going to have talked about some analysis, some applicable rules, right? And it'll hopefully show that you gave a good faith analysis to why you did what you did. This in my time has never come up, but I do need to be clear, you're not going to be able to hide behind that email. But if it's something that comes up a lot in your practice, like I was talking about the insurance issue, you know, if you have something that you keep coming up against, you can request an ethics advisory opinion. That's not through the hotline, but if you email us, we can get you there. And what that does, it provides you a safe harbor. So if you have an ethics advisory opinion, which comes from the Ethics Advisory Opinion Committee, and you do what they say, no, the OPC can't prosecute you for it. The Supreme Court can throw out the opinion, right? But until they do that, you're safe behind that. Okay, we can give advice to you. We can't give it to non-lawyers, including your staff. I don't know the reason for that rule, but it's the current rule. So if you have your secretary or assistant call in or email a question, they'll be reaching back out to you directly. Okay, we can talk about your own conduct, not about other lawyers' conduct. So I can't tell you how many times people emailed and said, I'm in this case and opposing counsel did this and this and this, and isn't that a violation? And can't I get them recused and blah, blah, blah. No, we're here to help. Like, we are here to help you. We are not here to throw anybody under the bus or give you ammo in your, disqualification motion. There is an exception. So as you all know, there's a reporting requirement under Rule 8.3. So 8.3 says you have to inform OPC if there's been a violation of the rules of professional conduct that raises a substantial question as to the lawyer's honesty, trustworthiness, or fitness. So sometimes we do end up talking about somebody else, but this usually comes up with your friend or your partner or your associate, and you say, oh, I know that my buddy just did this, and I know it violates the rules. And so we talk through, okay, does it raise a substantial question, right? And usually it's people who don't want to report, and we're talking through, do you have a reporting requirement? But, sometimes it is opposing counsel that's done something so crazy, and we end up saying, okay, you kind of have to report this. But again, if you don't, we are never going to tell on you. So we are never going to tell OPC that you had a reporting requirement that you didn't follow through. We're just going to tell you we think you have a reporting requirement. And the last one, we can give advice about your prospective conduct, not your past conduct. So we're helping you make decisions going forward. If you find yourself in a tricky situation or you see one coming, we can't get you out of the one you already did. There's just nothing we can do with that. Okay, how do you find us? Gave you the email address. You can also go to the website right at the top, click on For Attorneys. When you hover over that, you get this huge pop-up. We're right in the middle. And it takes you to our webpage. Again, here is the email address. Seriously. Oh, and I should mention, I worked on the hotline until I got this new job. Our current hotline person is actually an ethics expert out of state, which is kind of cool because she's never going to know you. Right. I had an awkward experience of sometimes having to tell people like, hey, I'll help you with your question, but just so you know, it's me. And, you're never going to have that with her. So that's kind of an awesome benefit of her being out of state. It also means she's working at different hours, right? So if you email her at 2 a.m., she might get back to you at 4 a.m., right? Because it's a different time zone. So, and these are pictures of my dogs because that was really boring. So any questions about the hotline or my dogs? Okay, that's all I have.
All right, next we're gonna hear from Jessica Arthurs, who is, I see, doing double duty today. She's a participant and now will be a presenter for the Young Lawyers Division.
Hi, everyone. My name is Jessica Arthurs.
And I'm Nicole Johnston.
We are on the Young Lawyers Division Board, and similar to you, we're all we're both very fresh attorneys. We joined the Young Lawyers Division, I think just right out of law school. The Young Lawyers Division is a super active organization within the Utah State Bar with about 2,000 members, and surprise, you are all one of them. Everyone who is in the state of Utah who is under 36 years old or is within their first state bar, within under 10 years, is an automatic member of the Young Lawyers Division. And surprise, you are all paying for the activities of the Young Lawyers Division with your duties. So some of the resources available to young lawyers are we offer free or sponsored CLEs. We do some of the signature pro bono events, like we just had a presentation on, including the Wheels for Heroes program, which is run about 4 to 5 times a year. Or we also have the Veterans Legal Clinic, which we run about 1 time a month. You also have opportunities to get involved with the Utah State Bar. You can be a liaison to various initiatives they're working on, and you can also be a liaison to the American Bar Association, which does really cool nationwide events that you can join and meet other attorneys from all over the country. We also have some exciting events coming up, including the Wheels for Heroes program is hosting an event here this Saturday if you want to get involved. Nicole?
Okay. So there's 2 events coming up that we wanted to make you aware of. The first one is a new lawyers and judges event, and that's happening on Thursday, October 24th at 5:30 p.m. And they're hosting that at the Leonardo Art Museum after hours, which is a great opportunity to check out the art without any kids around. So that's a good option. And they're also doing food and drinks available. And then we also have our annual Young Lawyers Winter Gala, and that's going to be on Thursday, November 7th at the Living Planet Aquarium. Again, it's the aquarium closed after hours just for us, and so we have the whole aquarium open to us to explore, and it's a fun opportunity to dress up. The occasion is formal, dinner is served, and there's an open bar. So it's a great opportunity to come and meet and get to know your fellow new attorneys.
Awesome.
Is that it?
Yeah, and if you have any questions or want to get LinkedIn, our Instagram is Utah YLD, and the website is younglawyers.utahbar.org, and you can get in contact with our communications director Arrow Hahn, if you're not on our newsletter list. Thank you.
Perfect. Thanks, guys.
Thank you all. I will mention we are a little ahead of time, and I'm going to offer 2 options, and I'm assuming everyone's going to want to take the second. We can either take a break now or we can end early. Okay, that's what I thought. So we will go with that. So I want to, before I get into the standards of professionalism and civility, I just again want to thank you all for being here and for working through your mentoring plans. I will also say that, so my name, I don't think I ever introduced myself. My name is John Wyas. You've seen my emails. I am an attorney. I went through this program probably about 10 years ago now. I was in your position now. And I will say now that I'm in this position that the mentoring plan and the program really hasn't changed much since it started in 2009, which 2009 is a long time ago now. I feel it now. I don't think I'm that old, but that's when I was in law school starting. That was a long time ago. Before, right when the first iPhone was coming out. We didn't realize instrumental that was going to be and everything. But sorry, that's kind of an aside, but just to let you know that we are really interested in making this program better, and interested in your feedback on how it's going for you and what parts of the plan or like this program itself, like this program today, if there's ways that we can make this better going forward, we are open to that feedback. I will mention though that the one feedback is we can't make the program go away. So that's the one thing, that this is a Supreme Court mandatory program. If we were to do that, we'd have to go to them, and I do not think they will be open to that, since a few of them that were instrumental in creating the program are still there. So I will say that I have had that feedback from friends over the years. That is one bit of feedback that will not see much traction going, but we do want to make it better on you as mentees, but also for your mentors. If you feel like any parts of the program that maybe are a little too onerous or don't really apply in practice, like I said, because we really are taking a really deep dive right now to really overhaul this program to make sure it's applicable for the most wide array of people. So I think we know we've already identified some places that maybe aren't really applicable for everyone, or for like a large swath of attorneys. So we want to find those spots and find ways that we can, like I said, make this still useful, but like, so it's not feeling too overwhelming, but still useful. And also we want to hear how things are going. So if you ever have any issues with mentors, we'd like to hear that. We hope that most mentors are actually working through the program and doing what they're supposed to, but we do know that they're, like I said, from hearing now, but also over the years from friends, that there are unfortunately some mentor groups that really aren't doing anything. So, but still passing off the program, which is not the goal of the program. We really want this to be beneficial and for you to gain experience and resources more quickly to get into practice and feel confident. We know, again, that law school doesn't really teach us really anything about how to be a lawyer. So we were hoping this program, I shouldn't say anything, if you're in the clinics and those kind of things, you're getting some of that experience. But the overall philosophy of law school is not really to teach you the day-to-day business of being a lawyer. So we hope this program is providing some of that for you. And if it's not, we want to know that and know how we can make it better. So with that, I just want to quickly go over kind of the standards of professionalism and civility. It is a little confusing because we do have the standards of professionalism and civility, but also the rules of professional conduct, and they're slightly related, but two different things. And I was always a little confused, like, well, it seems like a given, like everyone should just be professional. Like it seems like everyone should know that, like, and we should be civil to each other. But it unfortunately is not the case. And actually it's fairly recent history when these standards came about. So it was in 2001, the Utah Supreme Court, they created an advisory committee. And it was led by Justice Durant, who is now our Chief Justice of the Utah Supreme Court. He was charged with with running this committee and coming up with these standards. And these were released in 2003. And shortly thereafter, I forgot to write the date, but I think it was 2006. The Utah State federal courts, the trial court level, they adopted these or kind of gave their blessing to them. And as Judge Humes mentioned, as he read the oath, those were integrated into the oath in 2009. And there has been, so these standards, I'll just mention, kind of like our pro bono rules, they're aspirational. We're hoping everyone just kind of will see these as a given and follow them, but they are aspirational only. Like you can't be like held in, like it can't be anything brought against you because you are not following like rule 14 or standard 14 or whatever. And there have been attempts over the years to codify these and bring them kind of more mandatory, but those haven't been successful. But I will bring this up. So I was talking over with my boss yesterday about these standards. And anyone who knows soccer, you know that there's yellow cards and red cards, and usually that's for something pretty bad you've done. You get a card, and yellow, you just get a warning. Red means you're out of the game. But one other way, this is idea of persistent infringement. So that's when, say, you're just doing a lot of little fouls a lot over the game, like the referee can give you a yellow card because, like, okay, you've had enough warnings, you've been doing enough little things that I think that's bad enough. And I apply that to the rules of professional conduct. So like was brought up before, there is rule 8.4D, which is the misconduct rule, which is it's professional misconduct for a lawyer to engage in conduct that's prejudicial to the administration of justice. And like was spoken, like that's really vague. That could really mean all sorts of things. But in the comments, comment 3A, they have mentioned that this is kind of where the standards of professional civility, even though they're aspirational, they can come into play in any like misconduct issues. And the comment in part says an egregious violation or a pattern of repeated violations of the standards of professionalism and civility may support a finding that the lawyer has violated paragraph D. So that is one way, and there are some court cases. There's a list of them. I kind of lost my notes, but it's really not that important. But there has been times when the judges have used this in cases with like malpractice or misconduct cases against attorneys. Like I said, they're aspiration, but they have shown like this, if they can see a repeated pattern of this activity, they can use that as grounds for misconduct. Like I said, in this vague reading of, well, how vague 8.4D is, that can be one reason they can bring that up. So I'm just gonna, I printed these out, this little packet. This is kind of your homework. I'm not gonna be checking in, so it's just something to look over. The rules, the standards are printed here. And then I also printed out this. You can find this on the Bar Journal. This was in, I believe it was the November-December issue of the 2006 Bar Journal. You can find the Bar Journal online. It's on our website, or if you just Google Utah Bar Journal, it's there, and they have archived versions. And that issue it's all about the standards of professionalism. That was like, so 3 years after the rules came out, they had this whole bar issue about that Bar Journal issue. And I'll just give a little bit of a caveat. So this says 2006, so it's a little bit older. And the attorney is great, but he practices in securities. So all the scenarios are securities scenarios. So which is not, unless you're practicing there, it might be super relevant, but maybe not as relevant, but you can get the idea. And I'll just kind of give away some of the answers, but and you'll probably figure this out by looking at how many there are. So there's 20 scenarios, and I print out the standards because each scenario matches up with the corresponding number. You can it's kind of to see how these standards play out in practice. So I encourage you this when you have time, just to look this over and to understand kind of the why behind why we require attorneys every year to get at least 1 hour of professionalism CLE, and it's just to continue to remind ourselves of these standards and this call to remember our professionalism with ourselves, but also with our staff, our opposing counsel, our clients, the court, like Judge Humes was saying. This is people around us in the legal community that are really helping everything run. It's all very vital. And then that's really it. So if anyone has any questions for the whole group, I can take those now, or I'll be here if you want to come up and I can answer those. But if there's no questions, that's it. And I'll give you back some of your time, and thank you for all joining us today.
I just want your-
It's a little free effort.